गुप्ता साहब।
जी सर। Yes. So I think we have around 32 participants who have joined, so we can start with our session.
Yes, yeah.
So I'll just put my deck on the screen. So welcome all. First of all, I would welcome all the panelists, Sudeep Gupta sir, Sanjeev Pandey sir, and Vidarbha sir for permitting us to get enlightened by your gracious presence. And also, dear participants who have spared your time and to come in the panel discussion. I would give a brief introduction of the panelists with which we can start with this. Then we can have a small introduction over our topic, and then we can start with the session. Shri Sudeep Kumar Gupta sir is currently serving as the accountant member at the Madhya Pradesh Commercial Tax Appellate Board. He joined State Civil Services as a sales tax officer in 1983 and successfully worked in all branches of the department. He retired as a Deputy Commissioner Commercial Tax Indore in February 2021. Sir has played an important role in designing first ever scheme of liquidation of old arrears in 2002 under tax laws. He was also amongst the committee of 25 members which drafted the GST law, and also a member of Law Review Committee and GST Law Committee till 2021. He has held more than 100 seminar sessions on GST, indirect tax laws for departmental officers, tax consultants, and trade associations. He has advised many government entities of MP and other states on tax policy issues. As a person with enormous expertise and knowledge in the field of taxation, his role is very useful in the discussion on today's theme, which is analyzing the judgment of Honorable Supreme Court in Rainbow Paper and Vidarbha Industries. Our second panelist is Sri Sanjeev Pandey. Sir is currently working as a consultant insolvency and restructuring at DSK Legal Law Firm. Sir has recently retired as a DGM NCLT and policy of Stressed Asset Resolution Group of State Bank of India. Mr. Pandey started his career with State Bank as a probationary officer, and during his 36 years journey with SBI, Mr. Pandey also carried international banking exposure as a head of treasury at SBI Singapore from 2009 to 2014. Sir has been associated with IBC since its inception on account of his deputation to IBBI at the initial period when the rules and regulations of IBC were being drafted. That was in 2016 and 17. He was a coordinator in various working groups engaged in drafting of IBBI regulations for CIRP, liquidation process, voluntary liquidation, information utilities regulation, and regulation for IPs and IPS. Sir was also involved in drafting of question bank for IP insolvency examination, which is the limited insolvency examination, training of newly registered IPs through a number of workshops at Delhi, Mumbai, and registration of IPs and IPS. He also participated in working groups on personal insolvency, cross-border insolvency, and group insolvency. On his return from IBI, Sir was posted as head of NCLT division at SBI. His role included drafting of banks' policy guidelines, SOPs for CIRP liquidation, individual insolvency, pre-pack, and other areas of IBC. Mr. Pandey was also responsible processing proposals for initiation of monitoring more than 1,000 CIRP and liquidation matter and another 1,200 matters of individual insolvency. Our third panelist is Shri Vidarbha. Sir is an advocate having diversified practice mainly in corporate tax, civil, criminal, property law, commercial laws, and economic law matters. He is a fellow company secretary as well. After he holds a more than 3 decades experience in the profession and also as an insolvency professional. Apart from his regular practice before the MP High Court, Sir is practicing before the Supreme Court, NCLTs, NCLAT, and other courts and tribunals across the country. Further, Sir has also been providing consultancy, advisory, and litigation services to various central government, state government, PSUs, banks, and corporates. Sir has been on panel of all major banks since over the years and has been the senior standing counsel of the Income Tax Department from the period 2017 to 20 and the Central Board of Indirect Tax and Customs from 20 to 22. Relevant to the current theme, sir has a combined expertise in the field of corporate laws, banking laws, and taxation, both from the side of government department and as well as from the side of banks. We welcome and all the panelists to this panel discussion. I'll move towards giving a small glimpse of our today's the two judgments which for whose discussion we are gathered today.
Alert from system solver. No battery.
Yes. So now the first we would like to start with the judgment of Rainbow Paper. In this judgment, the Honorable Supreme Court has made a few important observations which had brought these the state, the tax authorities and the tax dues at par or pari passu with the dues of the secured financial creditors under Section 53 of the code. If we see a brief facts, what has surrounded in this case is that there was a claim which was filed in with delay by the Gujarat's VAT department, and that claim, when filed, it got rejected owing to the mandatory timeline in the IBC code as regards the admission of claim, which was also further held to be mandatory by the Honorable Supreme Court in JP Kensington judgment of 135 days being mandatory, of 90 days being mandatory. After the claim being filed in delay, and the claim being rejected, the department went in on an application challenging the same before the Ahmedabad NCLT. And along with his plea, another plea was as regards unfair treatment in the resolution plan and not being paid at par with the secured financial creditors. What made the department claim this was the Section 48 of the Gujarat Value Added Tax Act, which provided that any due towards the state tax authorities under this act shall have a first charge over the property of the concerned assessee. This being the premise, they claim to be a secured creditor and not being paid at par with the secured financial creditor under a resolution plan. They challenge the same. This particular challenge of the department wasn't permitted at the NCLT and NCLAT level, but the Supreme Court in the recent judgment of Rainbow Paper have categorically dealt with these this section, and it had noted that there is no contradiction with Section 53 of the IBC, and there is and Section 48, which would make IBC have a overriding effect over this section. And this being the reason, there are two important findings in the judgment. One, the Honorable Supreme Court has held that when there is a recovery notices being served on the RP or the corporate debtor, and it is within the records and the books of the corporate debtor, first of all, there is no need of filing a claim. And once a claim is filed, then the same need to be treated at par with the secured financial creditors as per Section 53 of the IBC. And following which, a resolution plan, if it does not provide the fair and equal proportional treatment to the tax dues, the same resolution plan needs to be rejected. This is the finding of the Honorable Supreme Court in this judgment. On this, now I would call upon Sudeep Gupta sir to provide his view on this judgment. Then we'll move to the other panelists. Welcome you, sir.
Thank you. The very first thing is, Rohit, that this is a subject which is usually not our regular subject. So I am thanking you for inviting me. And now comes Dubey sir. Dubey sir is a very great advocate. I was in contact with him in several of cases where he was opposing me. And there I found the depth of knowledge and understanding. It has bewildered me. And I find him very enthusiastic and cooperative. Sanjeev sir, though he joined services late, but he joined as probationary officer in a bank. In the same bank, I was a clerk. That way, he is still my senior. So I start my subject. You see, there are tax laws as per the constitution by the state as well as center. The latest tax law is GST, which applies on the service on the supply of goods and services both. Tax is a government charge. A government cannot function without the collection of tax. So the priority of tax collection has to be there. Under GST, Section 82. Section 82 talks about first charge on property of defaulter. Here, I'll read the section. There is one noticeable element. Section is notwithstanding anything to the contrary contained in any law for the time being in force. This is general. Now I am coming to specific. Save as otherwise provided in the Insolvency and Bankruptcy Code 2016. Any amount payable by a taxable person or any other person on account of tax interest penalty which he is liable to pay to the government shall be a first charge on the property of such taxable person or such person. The important point is, under GST law, a provision, exception for Insolvency and Bankruptcy Code has been provided. This is first point. The second point is regarding VAT laws. I have definition of many VAT laws, and Rohit sir has been kind enough to send the definition to rest of the participants also. Nearly all the states where a tax is levied, they provide for first charge. But in state VAT acts or even Central Excise Acts, they do not provide exception. The very first thing I pointed out under GST, exception for IBC has been provided, whereas in other acts, exceptions are not provided. For simplicity, rather understanding, I'll read one definition. This is a definition of Kerala General Sales Tax Act 1963. Section 26B. It says, tax payable to be first charged on the property. Section is, notwithstanding anything to the contrary contained in any other law for the time being in force, any amount of tax, penalty, interest, and any other amount, if any, payable by a dealer or any person under this act shall be the first charge on the property of the dealer or such person. Just to bring harmony, GST law provides exception for IBC, other VAT laws which were functioning in full force till 30th of June of 2017, and now they are working for limited commodities. They still do not provide for IBC. Now, the thing is that states, the government, they want to keep their superiority. They are called crown also. There was an earlier judgment under Sarfasi Act. This judgment is Central Bank of India versus State of Kerala and others. It was delivered by Supreme Court on 27th February 2009. In this case, Supreme Court, it took out a part of High Court judgment against which the Central Bank of India had gone to Supreme Court. It says, if any central act provides for first charge, the charge created under Section 38C of Bombay Sales Tax Act is overridden. Conversely, if the central act does not provide for first charge in respect of the liability under the said act, the first charge created under Section 38C of Bombay Sales Tax Act shall hold the field. This way, the High Court pointed out that under the Securitization Act, non-obstante clause was not there. Supreme Court referred to the definition of DRT Act and Securitization Act and came to the conclusion that crown dues are superior. They referred a case, that is Dena Bank versus Bhikha Bhai Prabhudas Parekh. It was reported as 2005 SCC 694. In this case, the Supreme Court decided there are 3 points. I'm reading 1, 2, and 3, all the 3 points. There is a consensus of judicial opinion that the arrears of tax due to the state can claim priority over private debts. The word is can claim priority over the private debts. Number 2, the common law doctrine about of crown debts, which was recognized by Indian high courts prior to 1950. I'm using my words. 1950 is referred for Republic Day, which recognized by Indian high courts prior to 1950 constitutes law in force within the meaning of Article 372(1) or and continues to be in force. Basic justification number 3. I'm reading number 3. The basic justification for the claim for priority of state debts is the rule of necessity and the wisdom of conceding to the state the right to priority in respect of its tax dues. Supreme Court in this case, in para number 38, uttered, if Parliament intended to create first charge in favor of banks, financial institutions, or other secured creditors on the property of the borrower, then it would have incorporated a provision like Section 529A of the Companies Act and ensured that notwithstanding series of judicial pronouncement, dues of banks, financial institutions, and other secured creditors should have priority over the state's statutory first charge in the matter of recovery of dues of sales tax. This way, the decision was given in favor of Kerala state, and this decision continued to rule, still ruling, but since the IBC has come in 2016, the situation came like that. IBC was resolving the cases very fast, and the sales tax people, they could not get the knowledge that there is a case, and the resolution plan was such that it did not consider the dues of a state. Under this judgment of Rainbow Papers Limited of 6th of September 2022. The court has held certain points. When the tax officer approached NCLT to claim its dues, the NCLT held that the claim was made at belated state, before resolution professional as well as before adjudicating authority. The counsel of the defense, he pointed out that tax dues comes within the meaning of operational debt and they do not fall under the category of secured creditor. This way, the claim was rejected. Then the matter went to the appellate court. The appellate court also rejected it. Before the Supreme Court, Additional Solicitor General, he pointed out about the regulation number 36(2) of the regulations 2016. There he pointed out that the information memorandum shall contain the following details. One of the details is financial statements, audited financial statements, last 2 financial years. Any material litigation and an ongoing investigation or proceeding initiated by government and statutory authorities. The Supreme Court has ruled that under para 48, a resolution plan which does not meet the requirements of subsection 2 of section 30 of IBC would be invalid and not binding on the central government, any state government, any statutory or other authority, any financial creditor or other creditor to whom a debt in respect of dues arising under any law for the time being in force is owed. That means it is the duty of resolution professional to consider all the dues. Next.
Yes,
Sir, we are having a little time constraint. We have to move.
I'll take two or 3 minutes more.
Yes, please, sir.
I'll jump. In para 52, the court observed, if the company is unable to pay its debts, which should include its statutory dues to the government, and there is no plan which play dissipation of those debts in a phased manner, the plan will not be accepted. In para 54 of the judgment, committee of creditors, which might include financial institutions and other financial creditors, the words are important, cannot secure their own dues at the cost of statutory dues owed to any government. Now my last point is para number 57. It says the state is a secured creditor under the GVAT Act. Section 330 of the IBC defines secured creditor to mean a creditor in favor of whom security interest is created. Such security interest could be created by operation of law. Last line, very important. The definition of secured creditor in the IBC does not exclude any government or government authority. all the observations are over. The last point is state needs money. State is the authority which has created IBC or any other thing. If the state does not get its dues, it is very difficult to function. So now my points are over. Kindly proceed.
Thank you very much.
Sir, with this, let us take a short, quick view of Sanjeev Pandey, sir, on as a banker's perspective on the rainbow judgment. Sir, you are on mute.
Yeah.
Yes.
So thank you, Rohit, for inviting me here, and I'm very honored to be in company with Mr. Dubey, senior lawyer, and Mr. Gupta. So these forums are required for discussion, and these two judgments, Rainbow and Vidarbha, have really agitated all the stakeholders, not only the tax authorities. I think everyone has jumped up in what has happened. Suddenly, after almost 6 years of promulgation of IBC, we are going back to the initial situation. So let's first understand what exactly IBC was created for. So that if you see, IBC is generally a derivative of other insolvency regimes, already prevalent or very mature regimes in UK, USA, Australia, Singapore. So we have taken a lot of ideas, and that is the BLRC report, which has drawn upon so many jurisdiction and so many laws of resolving insolvency because of these Western capital economies in their experience of handling the resolving the disputes and insolvency. So if you read the preamble of the code, that gives a gist of the idea behind the code. And as like our constitutions, preamble is the basis of any law. So if you read the preamble, so in order of priority, the law says, or the code says, that the code is created to resolve the insolvency of corporate persons, partnership, individuals in a time-bound manner. So time-bound is the first priority. Where in this particular judgment, somewhere the court has said time is just directive. So they have thrown away the rule book. Even Supreme Court in various judgments, despite saying that, okay, timeline may not exactly be adhered to, but there, because this is economic law and money has a time value. So if you don't adhere to timelines, you are putting the country, the economy, everyone at a loss. And I can share the example of SR Steel, where it took almost 3 years to decide. 42,000 crores available in a resolution plan. The money could not be taken by the banks for 2 years just because of litigation. And you just imagine, for a poor country like India, if we lose money like that, so forget about taxes. Time value of money, so we will remain a poor country or a low class, middle class country. We will never become a, because you see the capitalist countries, why they have adopted this law, they know the time value of money. If the early you release the stuck assets, whether through resolution or liquidation, you are losing value. That is fundamental of economics, fundamental of modern finance, that any stressed asset is like a melting ice cube. The early you use it, you get some ice. The later you use it, it becomes liquid of no use. So that fundamental thing, all of us stakeholders, including our courts, don't understand. So we are losing money day, night, every day. Like, that is one part. So first, this thing is time-bound manner. So this takes slightly different view from the court judgment that time is irrelevant. So after maybe 4 years, 5 years, the court can take to decide. That I differ. Second thing is maximization of value and to promote entrepreneurship. There I have some reservation with the particular section 29A added later, which has actually distorted the basic character of the law created by BLRC, the IBC, where all the three stakeholders like CD, the OCs and the FCs were entitled to submit a resolution plan. And I am of the view that most of the litigation today under IBC is because of that section 29A, where the promoter tooth and nail fights to avoid being admitted to the court. Even though law is very clear that this law is not for recovery, this is for resolution. It is like something if you have a relative who becomes sick, he is critical, and you are taking him to a hospital and he is resisting, no, I don't want to go, I may die on the bed, I won't go to hospital. Exactly that is the situation created by that section, that we have a company which is sick, which is struggling, which is insolvent, but now they are fighting tooth and nail in the court. No, I don't want to go to a hospital, which is IBC, and I don't want to see a consultant or a specialist, which is the RP. So that is second thing, and that is killing the entrepreneurship. Why? Because many of these cases are going into liquidation, because other than the promoter, no other company or an investor is coming in to buy these assets. So 80% of the cases are going into liquidation. That is the second part. Then availability of the credit, balancing interest, and last thing I will counter what Mr. Gupta said, that sovereign debts under common law take superiority, that was there till 2016. Here, because of the international norms, even countries following the common law like UK, there the government dues, sovereign debt have taken a backseat, and accordingly, the law provided, the preamble says, alteration in the order of priority of payment of government dues and establish the insolvent regulatory board. So government has deliberately, the sovereign has deliberately taken a backseat. So they don't want to enforce this super priority. And later on, they have adopted same fundamental in the SURFACE Act and RDB Act also. They have modified the act. So this is the basic part. Second part is, if you start reading the law as a lawyer or as just line by line, this law is nothing but provides a process for resolution. And as I read it as a banker and as a credit analyst, I've been in credit for almost 25 years of my job. And I have handled like right from giving birth to accounts like startups, MSMEs, medium enterprises, corporates. I've handled all of them, including their insolvencies, their restructuring, their demise, everything I've handled in BFR, CDR, everything. So what I can see here is that unless you look at the law in a positive, in a beneficial manner, you just look at it in a very hardcore, if this is written in the code, code is nothing but a process provided for early resolution or early liquidation where the unit is not viable. So the economic of the law says where the corporate debtor has some economic value and it is the COC considers it as a viable unit which can be revived, so it should be revived through a resolution plan. If the COC thinks that this is a gone case, it is defunct, cannot be revived, it should be immediately taken to liquidation so that the assets of the corporate debtor can be sold in the market and the creditors get their dues, and those assets are again used by some people who get them at a cheaper rate for some economic benefit of the economy. So this is fundamental economic idea behind the code. So here, as I see in this particular judgment, code has gone too much into the lines of the code rather than looking at the resolution aspect of the code, which is a very flexible law. In all jurisdictions, the insolvency judge has supreme discretion to decide to keep the company running and to resolve. Because ultimate is you have to resolve first. Liquidation is the last resort where resolution is not possible. Coming to this judgment, I see problem 2-3 places. Like one is this, the tax authorities or government authorities don't have to file a claim. As I understand, because I was part of the team drafting regulations, if you, and that is because that deliberately why this claim time was limited, because earlier in BFR or CDR, we have seen, and I think Mr. Gupta will agree with me, the tax authorities will not file a claim for 5 years, 6 years. What is the hurry? We are sovereign. We have super priority. Why should I bother? And most of these resolutions failed because tax authorities just did not bother to file a claim. Government was very, very knowledgeable about this. They knew it. If our people are so lethargic because they know we have a super priority. Even if bank recovers something in SURFACE, we will stand first in the queue. We will get. Let the bank bothered about recovery. We will get our dues without doing anything. without even filing a claim. But now, since this law is given a lower priority, so there are, I think, many judgments of the Supreme Court, including some of the judgments mentioned in this particular, where the court has said, for in the custom authorities case recently and in the income tax authorities case, if you have not filed a claim within the time before the resolution of the company, so you cannot, your claim has basically vanished. You cannot come to the court after the plan is approved that we have a pending claim. No. So this particular judgment has gone counter to that and basically demolished that idea of the BLRC that everyone has to be disciplined to keep it a time bound. They have taken a particular very narrow view of this section 12, which was before its amendment, where it was only required for proof of claim to be filed. Later on, it was amended, the claim has to be filed. So I think that takes care, because that law is already amended. So this will be applicable only for old cases. So I have no issue with that, but this is taking a narrow view of this particular judgment. Otherwise, if you don't file a claim and you keep sitting on your claim and the last moment, even when resolution plan is approved, and then suddenly you approach the court, so I think this will only lead to litigation, no resolution, and the applicant will be very hesitant to apply for resolutions. Then there is a problematic area which I see. GVAT, of course, the court has been right in declaring the VAT authorities' dues as secured, because they fall very much within the definition of secured creditor. So I have no issue with that. That judgment is correct. Only problem here is the code, which has under section 53 says only secured creditors. I think if government really wants to promote this resolution, they may have to come in for some amendment where they should declare the secured creditors as secured financial creditors. And if they want to take better care of secured operational creditors like tax authorities, so they should clearly define them in the priority order, somewhere in the section 53. That will take care of this. Otherwise, on this point, I agree with the court that as per the definition given in the code, tax authorities, VAT authorities are secured creditor. I won't say that for GST, because GST, as Mr. Gupta also shared, it has an exception provided for IBC. Then comes the entitlement of powers of COC as a banker, because I have been responsible for many COCs. Here I see the problem in this para 53, 54, where basically what the court has tried to convey is that resolution plan, even if approved by COC and the adjudicating authority, is not full and final. So can be opened at a later stage on some pretext. I think that goes counter to many previous judgments of Supreme Court itself, where they say that once the plan is approved by adjudicating authority, it is full and final. And unless you have this provision in the law, so this law fails. This is basic fundamental of any insolvency law, where there has to be a priority, there has to be some fundamental conclusion, because one person has taken this company over through a resolution plan. Suddenly you open that plan and start reallocating the distribution. So COC here loses the power of distribution under resolution, because COC has been given some flexibility, although they have to follow the section 53, but not in a hard and fast manner. Basically, they have to convince the creditors to get the plan approved. So they have to get votes, 66% vote to get it approved. If section 53 comes in there, they may do some give and take. But since tax authorities, first of all, they will not be part of the COC because they are operational creditors, even if secured creditors, and they will fight for this share. So I think most of the time this will lead to liquidation, and which is not the fundamental purpose of the court. So here the court has created a lot of confusion because of this 2-3 paragraphs. Then even they have challenged the discretion of the adjudicating authority, or said that if they have not exactly followed section 31 while approving the plan, or section 30(2) and then 31, so it is not binding on the government authority. So I think that is a wrong stand to take, because if any stakeholder is aggrieved by this plan, he can always go to the next superior court for appeal. But just to say that no, if the authority has not seen, so that plan is outright rejected, that is dangerous. I think that will lead to more liquidations, and then the basic purpose of the IBC will be gone. These are few things I think I have to share. Maybe later on we'll add something. Thank you. Thank you.
Thank you very much, sir. Having heard Sanjeev sir and Gupta sir on two extreme views, let's have the view of Vidarbha sir. So I believe it should be more mixed view as regards the department and bankers are concerned.
Good morning. Thank you very much. And I'm fortunate of having the two veterans with me in the subject relevant today. One is the leading banker and having the exposure with the instrumental to insolvency coming this place. Another is another veteran from the tax department. Since post this rainbow judgment, we have got the very bullish action from the tax department, and which is going to create a lot of challenges, whether the pending resolutions are so and so. And presently, since the IBC is the most dynamic law and having the very diverse implications, earlier Gupta Sahab, we will be dealing with the subject of taxation or any other statute who are having very limited to that role only. The IBC is very diverse law. It deals with the all multiple laws, all the organs of the business, and it is going for that. That's why everybody is interested in this, whether the corporate debtor, whether the AFCs, whether OCs, or even whether the workmen's or even the tax department. That's why it is very challenging. Coming to the point, basically, since this law is created into, that's why the law, I'm slightly agree with the view of the Pandey Sahab ki the law should not be read as the literal interpretation, which we are doing generally for the tax laws. It has to be taken to the purposive interpretation in that way. Although it is with the due respect to, it is the now a law of the land. And when I'm going to as a law student and reading that, even I would have done that and it is created the serious challenges unless the law, unless the Supreme Court, Honorable Supreme Court is coming with the review and making some amendment, looking to the challenges and looking to the preamble, looking to the BLRC report and all these, the spirit of the resolution for which we are here. Otherwise, leaving it to the complete limbo and creating the lot of litigation from 3 to 13 years, anything can be we advocates, we may try with the help of the tax department, Gupta Sahab and all these, we may take it forward to long battle. But in my view, I think the two serious challenges created certainly in all organs, whether it is a resolution plan or anything. But either it is going to have review of the petition in the due course, otherwise the summary amendment by in the as suggested by Pandey Sahab, I think it can be made by of the classification that can assist if the Honorable Supreme Court has defined in this judgment is the secure debt being as the charge is already prescribed under the statute, and incidentally the most of the tax institutes of the country are claiming the charge, and in otherwise also the other, even the dues, even the municipal dues and other, they are saying has to be collected as a land revenue. And basically by way of such interpretation of the law, you are having certainly the charges over the property. We have to again maybe legal question to deal, being the secured debt vis-a-vis being the charge holder, whether both are the same, whether the 52 subsection 3 dealing with the certain provisions to have the secure debts to prove how going to have any relevance in the matter. But I think after the Honorable Supreme Court has categorically came with the certain directions in the matter, there is hardly any judicial application of the mind further is required is left with the advocates like us in the matter. And basically Honorable Supreme Court come with the two things in there. One is the declared as secure debt in the matter, and similarly they have said they should be upgraded and in the part of the second levy along with the workmen's and the other secured. And the law is already prescribed them at the secured OC. They were the OC, now they have became the secured OC with this judgment. But certainly they are not the secured FC. But since the particular provision deals with the secured debts only, that's why it is creating the serious challenge. I slightly and with the view of the Pandey Sahab in this matter, with the BLRC report, with the European law, with the ease of doing business to ease of exit is also equally important, with the experience of SICA, with the experience of SURFACE, DRT, what we have handled. It is the very fastest wave. And the last 5 years, I'm quite happy the number of industries, although we tried a number of things where the challenges, even the number of history amendment government came time to time, it became very dynamic law. Number of amendments proposed 2016, even the Honorable Supreme Court has came with the very dynamic interpretations in this time to time again and again. And I think with this, although earlier we have not come across with any such serious challenges with now, which I have faced with this rainbow today, even the law of limitation in interpretation earlier, where that is the, but issue is that in this case, how certainly it is not going to be in the spirit of resolution. Gupta Sahab has pointed out the revenue is very important for the exchequer and public interest that has to be paid. But the spirit of law is that we cannot collect from the dead and sick body. It was the spirit to get it resolved and make it operational so that better revenue can be collected in due course, which we were not succeeded in the past. That's why the spirit of the law. And that's why the government came with the biggest sacrifice. No problem. I will be putting, let the secured debt creditor on the first side, let the workman dues on the higher side. Let me little below than that, since it is in the interest of the overall interest in the long run. That's why that is the BLRC report. Certainly the preamble and the report is somewhere missing in this judgment, which I understand. But taking to the even the crown debt theory, which as a tax lawyer or as a department counsel, I argued in the number of cases. Now this law has given the more strength. Even I was not in a position to defend the department in the earlier tax dues and recoveries before DRT and any other forum. I think this judgment has taken even the much better forum. Now they have categorized being secured, being the first charge and all these. I think this is going to be the serious challenges. And again, I think Gupta Sahab is that basically tax better. You understand that tax dues, there are the multiple label. We are having the assessments, we are having the appeals, we are having the recovery, we are having the attachment. Which label? The moment assessment order or adjudication order is passed, demand is created. Even there is, when suppose there is an appeal, that demand is passed. Department is the next level of appeal. We are having 3 to 4 layer of appeal before the matter is reaching the Supreme Court. There may be turnout, there may be set aside of the matter. All these challenges are going to be very difficult when we are handling the resolution in IBC era. Basically, where the time-bound resolution we try to pursue, even the claim which Sanjeev Pandey Sahab has pointed out, the claim concept was that since with having the experiences time-bound, being the notice is published in the newspaper, it is a public notice. Everybody has to be. And being the department with the full-fledged, they should have the team, they should file the claim timely. And although we were trying to defend it, be able to get the order also and claim also, department was admitted in the past. But the question is not if I am dealing with a time-bound manner where the resolution and every day is very important to deal. Every step is very important. That's why whether I'm having the serious concerns as far there is no need of filing the claim by the department as far the resolution process, that is certainly going to delay. Again, going to the first charge in the various laws, not only the tax dues, even another number of dues who are having the charge over the assets by way of their respective institute, whether the municipal corporations or other, it is going to create serious challenges in my view. And I think with this background, I don't want to take the time when Rohit, you may go with the specific questions, and then when we're dealing with, we can put our contribution as required. Thank you very much. Thank
Yes.
you. And we are blessed with the excellent panel. I think I would be really bridging the gap between two great North Pole and South Pole.
Yes.
Thank you.
Thank you very much, sir. Now I would be pushing forward the posers, and any of the panelists can answer the queries. As regards the acts or statutes which were highlighted by Sudeep Gupta sir as well, which provides for the dues to have a first charge. My query is, so when we are looking at the statutes, whether so rainbow paper judgment is restricted to the tax dues, but what about the dues which also have a first charge under other statutes? For example, we have the ESIC Act, we have the PF Act, we have the MSME Development Act. So all these certain acts are provide for the dues to be enforced in the manner of a land revenue, or to be recovered in the same nature as a land revenue, and the land revenue also has a first charge over the property. So whether the implication of rainbow judgment can be far stretched or brought to an extent that it is not only concerned with the tax dues, and it is also concerned with the dues which are on first charge on the property, whether it is not a tax due. For example, if someone files a claim at MSME Facilitation Council and there is an award in his name, that is also recovered as a tax due. For example, there is a ESIC due, or there is a PF due. Those are also recovered as a first charge over the property, or being a land revenue, recovered in the same manner as a land revenue. So as per the understanding of panelists, how can we take this judgment's implication?
You may just present the questions on the screen. That
Yes.
will be better. I think we would like to go in very same order.
My screen is visible.
Yes.
This is the question which I have posed. So what are the views of the...
Yes, yes. I just told in my view, since it is the secure date and the number of institutes, including the tax department, has creating some charge. Whether is the law is required to be understood being whether the secure date or the having the first charge, both are the same, or going to have some differential treatment. I think the matter may be argued in the courts in the coming days. But certainly having the first charge, whether by Gupta Sahab has pointed out, it is going to be the operation of the law. And as a banker and as borrower, we understand when we are creating any charge in favor of anybody, that is then the charge is created. So whether the charge created by operation of the law is equally at par with the creation of the charge by the concerned person, and whether the charge would be what would be situation with the prior charges or both. But certainly with this challenge, even the land revenue, all the dues as appearing in the as a land revenue, they are going to have the charge over the assets. But only question that it has to be recoverable as land revenue. The land revenue is generally going to be restricted with the immovable property, are the things attached to earth. And then certainly it may not be extended to other assets. When the something is going to be their number of municipal and they are going to be collected with from the land or the building or immovable property. So there may be challenges whether that can be extended beyond or has to be restricted to that only.
Yes.
Over to Pandey.
Yeah. So I will just explain my view. So basically what I see as per section 12, filing of claim has to be supported by some proof. So even if the charge is created by the force of law or action of law, the charge has to be registered somewhere, because then only in a society where there are various stakeholders and who have multiple level of layers of charges, unless you keep a record, there will be total chaos. That's why we have a system of filing of charges. And after SARFAESI Act was amended, even Sarsai government has made it compulsory for any charge holder to file in Sarsai, and that creates a priority of charges. Whoever have a first charge, initial charge, may have a priority over a person coming later, unless they have some inter-se agreement where they pursue share the charges. So this is the fundamental of credit markets. So let us see from that angle. We like just saving one particular tax authority or somebody from their claims. Are we destroying some basic fundamentals of the society? Because what IBC brought in was a systematic exit, either by way of resolution or liquidation for a sick company, for a stress company. So if we start reallocating the rights, the credit markets will crash. So even in among secured creditor, there may be various priorities. There may be first charge holders, second charge holders. Now another category is created by this judgment, which is operational creditors secured. So they may have priorities, and those priorities and their sequence can only be decided by some filing of charge or some creation of charge in a particular register maintained by a particular authority. So here I don't know whether all these tax claims or these charges being claimed by tax authorities, whether they have filed any charges with these particular authorities like Sarsai or ROC, and if that is so whether which sequence they will file. So that I think some future judgment will decide. But this judgment has really created that confusion. Even without filing a charge, because the law is very clear, section 12, that the claimant, the stakeholder has a file a claim and then prove that claim with some supporting papers. So just saying that I have a revenue tax service, so you have to somewhere prove or somewhere bring some paper on record that this is my dues and I have filed these dues in a particular authority. So this is my order of priority. So that is the only thing I have. Thank you.
Gupta sir. Before Gupta Saab is being unmute, just quick view, Pandey Saab. Basically, as far the department and other dues is concerned, there is no requirement of filing. Actually, registration and filing is mandated under the some specific institutes like Companies Act and all these. But certainly, as far IBC is concerned, proof may be substantiated by way of assessment or adjudication order plus notice of demand. But that's why, and according to me, they have to certainly substantiate their demand and dues. That I'm okay, and that would be their assessment, adjudication order, and notice of demand would be sufficient to substantiate. And as far the registration of the charges, that is the certain institutes as prescribed, that is not required under the physical and other institutes. And the being secured debt classified by the Supreme Court, they may not be necessarily required to have the charges filing, and being again not with standing and specific provisions under the specific tax institute, that I think that has to be substantiated by the revenue accordingly. Over to Sunil Gupta Saab.
I'll just add to this.
Yes.
I just wanted to add, see, as a resolution professional, he has to know what are the dues, liabilities of this company.
Yes.
So, and the tax authority will not submit his claim because that is given in this order. They don't have to file a claim.
For that, I'm having my serious reservations, but as far the filing of charge, they have to submit something. That
no. So that is what. So first of all, they will not file a claim. Second, the RP will not be able to ascertain what are the claims because they have not filed a charge. So that compromises the basic fundamental of IBC, how to create an information memorandum, how to invite EOIs, because he doesn't know what are the exact liabilities. Some particular authority will not file a claim, they will not file a charge, and they'll not respond to him also. They will say at any time I can come in. So that creates a problem. So RP has to, whenever he comes in, he has to create OCs and FCs, 2 lists. Within 1 month of the CIRP admission, he has to create 2 lists, which he files in NCLT. One is the list of financial creditors and the operation creditor. Now, unless he has a claim or some proof of claim, how can he file, sir, this is the operation creditor secured as tax authority? That is my concern. Yes, this will demolish the entire thing. The basic structure is being demolished.
Yes. I think Gupta Saab will be able to solve this problem.
Of course, I will try, and I know very well that this is not a place where the problems can be solved. This is a place where everyone airs his own views.
Yes, boss.
And the persons who are attending the seminar or webinar, whatever you may say, they will take a decision themselves. The very first thing is the filing of claim by the tax officials. I agree that the Supreme Court has mandated the resolution professional to gather the dues. But despite there being the Supreme Court order, the government, that is the tax officials, they must submit their dues earliest possible so that the process is not delayed. In this regard, in my state, that is Madhya Pradesh, or I have relations with certain other states, I will try, that is of course unofficial, I will try to tell them that they should be forthcoming for submitting their claims so that the process is not delayed and the basic intention of the IBC to resolve the process in a time-bound phase is continued. This is a point that I wanted to make. And there are two more points. The first is about this judgment of Central Bank of India that I referred. It was delivered by Supreme Court in 2009. And there they referred Dena Bank versus Bhikhabai. I have referred it earlier also, but I will read only a few points. In paragraph 38, it says, if Parliament intended to create first charge in favor of banks, financial institutions, or other secured creditors on the property of the borrower, then it would have incorporated a provision like Section 529A of the Companies Act or Section 11(2) of the EPF Act. This is a reply for the query raised by Rohit. There is one more thing. These tax dues, in particular, sales tax dues or GST dues, they are dues of tax. This tax is recovered by the taxpayer from the consumer. This is a government money recovered by taxpayer from consumer to be deposited in the treasury. If he doesn't do it, there is another offense.
Breach of trust.
Yes. And now I am coming to the cases which have been explained by Rohit, that the earlier situation of the cases, earlier existing view being, he has referred three cases. The first is about Sundaresh Bhatt. Sundaresh Bhatt versus Central Board of Indirect Taxes and Customs. In this case, what Rohit has referred, that Supreme Court held that the IBC has an overriding effect on Customs Act, which too creates a statutory charge in favor of the customs authorities. The case is different. The case is different. Once a debtor or defaulter is admitted for resolution, there is a moratorium. During the time when there is moratorium, no authority is allowed to coerce the defaulter to make the payment of taxes. So the situation is different. Customs officer were trying to recover the money by way of confiscation or seizure of the goods. So to enforce the payment of tax or dues while there is moratorium, it is not allowed. That way, there is difference. The second case Rohit sir referred was Principal Commissioner of Income Tax versus Monet Ispat. In this case, the Supreme Court, in a very short order, ruled that income tax dues, being in the nature of crown debts, do not take precedence even over secured creditors who are private persons. In this particular case, the judgment of the Supreme Court is not clear to me. I am unable to understand. But in this particular case of Principal Commissioner, the Supreme Court followed, the Supreme Court has said that we are following the Dena Bank judgment. Now the Dena Bank judgment, what it says, these are the words from learned counsel for the appellant. The Supreme Court has observed, like, the learned counsel for the appellant is right in submitting that on the day on which the state of Karnataka proceeded to attach and sell the property of the partners of the firm mortgaged with the bank, it could not have appropriated the sale proceeds to sales tax arrears payable by the firm, defeating the bank's security in view of the law as laid down by this court in Commissioner of Sales Tax versus Radhakrishnan and others. However, here is the important point. The judgment says, however, still in the facts and circumstances of the case, the appellate bank cannot be allowed any relief. The bank was not given any relief. The judgment further says, Section 15(2)(a) of the Karnataka Sales Tax Act had come into force on 18th of December 1983, while the decree in favor of the bank was passed on 3rd of August 1992. That means the law of first charge was priority. What I want to emphasize is that the judgment in case of Principal Commissioner is not clear to me, but the Supreme Court has held tax dues to be superior. The final and third citation given by Rohit sir is about Leo Edibles and Fats Limited. In this case, again, the income tax was considered at lesser rank as compared to IBC. But if we read the IBC law has a provision that Income Tax Act will be amended so that IBC dues are given priority over income tax. The same has not happened in VAT laws. That means this case is again differentiable. Now I am coming to the last point. I'll take 1 more minute. The last point is that tax authorities of different states, they will now take steps as to what they can do to recover their dues. In case the matter is at NCLT level, they will file their claim. They will, of course, though the law has granted them the choice that they may not file the claim, but they will go and they will file the claim. And if the case has been adjudged by the NCLT, then they will go in the appeal. They will try to get their dues. Thank you.
Just a quick view. I think that this judgment is going to take us from the resolution to the recovery mood. I think the department and everybody is moving in that way. So that may be not been the right spirit. And as far the filing of the claim is concerned from the department angle, there is one view can be argued. Pandey Sahab, it is for the benefit of the participant. There may be argument from the revenue side in this matter. This is as far the tax dues are concerned, everything is in the position of the company. There is no need. The Supreme Court has gone in that spirit. There may be, if I have sold if I provided, sell the goods, supplied the goods or the services, if I have earned the revenue, then the CD should be the best person to know when the RP is taking charge in the position of all the books of accounts. He should know what is the tax dues. As far tax due, I need not to break our head to go with even they have not filed, so we should reconcile and prepare the list of the dues. In that spirit, I think that this judgment may be read, but certainly that is going to create number of challenges. Yes, Rohit, move to.
Yes,
I think we are having
I
rushing
think-
with the time. You can move quickly.
Yes, sir. I think we can have one more last poser, and then we can open the questions for the participants. One last question.
Rohit, give me 1 minute.
Yes, sir.
I agree with the Sanjeev sir that there should be some pressure or some requirement from the tax authorities that they should file their claim. Of course, as per regulation 36(2), the resolution professional has a duty to go through the financial statements, the latest financial statements, audited financial statements, and any material litigation. But still, the state tax officers, they must come forward so that the time is saved.
Yes, sir. Sir, also, like having heard all this, there is one poser which I see from my list, which still remains, is that there are, in majority of the cases, there is a possibility that there is a pending appeal or challenge by the corporate debtor towards the demand which has been raised by the department. In this scenario, if we go by the landmark judgment of SR Steel, of Honorable Supreme Court, the RP has to admit the claim at ₹1, considering the same to be a contingent debt. Having this in mind, so what would be, is there an implication of Rainbow Paper on the understanding which was earlier existing, that in case there is a pending appeal, we should admit it ₹1? After this judgment, will there be a different opinion or implication?
Just quick view before moving to other. I think either it is debt or not debt. If it is the debt as on debt, there is no concept of contingent debt in my understanding. Either if it is debt and if the order is quashed, and if it is the order is not passed as on debt, there is no debt. There can be only two situations, and there cannot be any concept of the contingent debt. Over to Pandey sir.
Sir, basically contingent debt situation comes because banks also have some contingency limits like LCs, BGs, so which are not crystallized. So we don't know what will be the debt created, because when they devolve, it comes into a fund-based category.
You may
So
say that is a claim. Even the claim, it is a claim. It is not debt, but it is a claim.
Claim, but yes.
But in case of bank, you have made the exposure. But in case of the tax dues and other, you have not passed any order. How you can say that something is contingent? That is my question. Over to
That is the thing. Yeah, Mr. Gupta to explain.
Gupta sir.
I'm sorry, I couldn't get the question. There was some disturbance.
Question is that from Rohit side, if something is no order is passed, is whether there can be any contingent concept and what can be there. Suppose order is not passed.
Sir, my question is, if there is an order of demand, but there is a pending appeal. So earlier, before Rainbow Paper, what was happening was, there is a judgment of SR Steel of Honorable Supreme Court which says if the RP is not able to decide whether there is a crystallized debt or not, then he should consider it as and if the particular debt is to be crystallized on the basis of an event or a pending suit or litigation, in that scenario, the RP has to admit the debt at ₹1. And then he should, once the debt gets crystallized, then he can admit at the entire amount. So this is what the earlier law was. Now, after this judgment, is there a possibility that if there is a pending appeal against an order of department in respect of tax due, can that claim be admitted at ₹1, or after this order, there is a different implication that we have to admit at the entire amount only?
Rohit, for the audience, this is a difficult question. You see, I am a member of appellate board. It is the highest body at the state level. There are cases before me which are under IBC also. The consultant, the advocates, on behalf of the defaulter or the appellant, they want me to defer the cases. They say that there is a moratorium. Sir, please do not decide the case till there is a moratorium. That means there will be no finalization, no crystallization of dues till I decide. And if I keep on deferring or postponing the cases, the amount will not be crystallized. This will further delay the process of resolution or liquidation, whatever be the case. So, in my view, the debtor or somehow the resolution of the case, the finalization of the case or the crystallization of the dues, it should be expedited. This is my view.
Just my quick view, I think the date of initiation of CIRP would be relevant. On that day, if the order is not passed by the AO, is not the quashed and not otherwise turned down by the any appellate authority, be it with board, be it with first appellate, be it with high court, but then the dues was there. Unless that order is overturned or set aside by any authority, that dues was there, Rohit. And when it is the overturned at any level, and then next appeal is pending, it may not be treated as the date. The contingent situation will be arise only in case where the order is overturned or set aside. If the order is already existing, the dues are not contingent, in my just little understanding in the subject.
Yes, sir. I think, sir, with this, should we allow the participants who have raised their hand to raise their query? Okay. I think Rajiv
We must
Dhingra
allow
sir
them.
has raised his hand. I'll ask him to unmute. You can introduce yourself and then you can ask your query, sir.
Sir, thank you. Thank you. I'm RP and RV as well. And in one of my matter, there has been a judgment of Ahmedabad bench that RP is not authorized to consider claims filed beyond 90 days, etc. In this particular case deals with GST, UT and state GST as well as central GST. Now, what happens is CGST and UTGST both file claim based on SCN, which was not finalized as on the date of ICD. They file the claim. I tell them, both of them are claiming same amount and with different rates, etc. What happens is I disallow them. You are late. Your liability is not crystallized. They have gone to the bench. The order is not passed as yet. But because the papers have been received and they had already gone to the bench, what I did was I informed the RP that such and such way some claims are there. In case the order is passed for their admission, they will have to be taking cognizance thereof. So the RP submits the plan. The plan is now, as on date, approved also as well. But the plan has a window. In case the order is decided in favor of the authorities, then that amount also will have to be taken for denominator purposes as far as distribution to government authorities is concerned. Now, day before yesterday, post passing of the order itself, post having received the money from RAs, SRA, that is, post that amount also stands distributed. Yesterday in the order, Honorable Bench has asked me to consider claim of Orissa GST department where they had filed earlier some amount erroneously, like 2.5 lakh they had claimed. I admitted the claim. That stands now taken care of. Against 2.5, now they are saying that their claim is not 2.5, it is 3 lakh. Yesterday, the Honorable Department has asked you consider their claim. What way I can consider their claim, and what will be the fate of this CGST and UTGST when the claim itself was not crystallized? SCN is issued sometime 6-7 months after start of my the CIRP itself. Kindly advise, sir. Thank you.
Just quick view before Gupta Saab will give a specific answer. As far the SCN is concerned, my considered view is that it is not the date as on the date of CIRP. So there is no need of admitting the claim. That is the one way of looking, since there was no adjudication order or assessment order as on date was there. That is one way of looking it. And second, as far the delay is filing, what you have told, certainly as a regulation, as a RP, I'm bound to go by that 90 days although as per the regulation is concerned. Certainly the post this Supreme Court judgment, that is situation is changed. You have to ignore the delay till the time you are accepting all the claims, even you are modifying the claim even beyond 90 days of the banker, COC, and it is working on the till the last time. That's why you have to consider even that delay. Now we are having Supreme Court judgment also of Rainbow in that. But as far as SCN is concerned, I am quite okay ki if there is no date as on date of the CIRP. So post issuance of SCN, even the issuance of SCN prior to that date, and no adjudication order was passed on the CIRP date. According to me, there is no date as on the date of CIRP. Over to Gupta Saab.
I don't have many words, but I will have to endorse the views of Sanjeev sir, who said that the tax authorities will not be prompt and they will, of course, unexpectedly delay the process. So I'm helpless. I can't say many things.
I think there should not be any comment from Gupta Saab. Pandey Saab would like to add something? We can move.
No, sir, that is the comment based on experience, because most of the BFR cases, CDR cases failed because tax authorities never bothered to file a claim.
With your experience, we are having IBC, sir.
Yes, sir.
We are in the IBC era both that. Yes, Rajiv ji would like to say something.
Yes.
Sir, what is happening in this particular case? My plan is approved. Plan implementation is already in place. FC has started getting its payment. CIRP payment has already been made. Bankers have been instructed to release the payment of those workers, etc. And now I am being asked to consider an error in submission by the GST department in submission of their earlier claim, which was already admitted. So there are 3-4 cases simultaneously going on, and
I think Rajiv Bhai post this Supreme Court judgment, even the approved plan and clean slate theory is going to be under serious challenge.
Yes, yes.
And even
And I think
would like to one more. I would like to add one point.
yes.
In case of SICA Act, under which the BIFR was created, state governments, all the state governments were asked to formulate some policy, and through which the relief was allowed to the industries. Such direction, I'm not sure who will take the initiative, but such direction can be given to the states.
I think recently CBDT gave some direction to income tax
Even
authorities.
CBIC has issued. Even CBIC
Yes.
has issued. But I think post Supreme Court judgment, the government may be more powerful to not to act on. No requirement of any such directions.
And problem with this judgment is
No,
that
Dubey sir, let me object. Sir, let me object. As I told you, as I read the law, the Income Tax Act has provided that it will not be having first charge over the property of defaulter. There is an amendment. It is in the IBC as well as Income Tax Act, both. The Supreme Court judgment, I will go back a little. I told you about it. This Louis was the name.
I'm okay with the law, sir. But my question is only that I think this is going to create operational challenges. Here we are going to just discuss the operational challenges, what we are going to face, and rather those operational challenges may creating the opportunities for advocates like us. There may not problem, but there's going to be operational challenges for the RP, operational challenges for the COC, and operational challenges for the time-bound resolution plan.
Yes, sir. Sir, should we move to the next question?
yes.
Yes.
Yes. Mr. Murali Krishna has raised his hand. I'll ask him to unmute.
Sir, good morning, sir. I am KMK Prasad, Murali Krishna Prasad, working as RP in a couple of cases.
Good.
In one of the matter, I have received a claim from Central Excise as well as State VAT Department after 90 days. And also the amounts claimed pertains to much older dues, much prior to 2010, 6 to 2015. 2015, 2003, like that. What is the implication of limitation act on these dues? Can we reject them because they are beyond 3 years if there is no confirmation of debt by the corporate debtor?
Just my quick view, I think even there is no exclusion of the law of limitation with my understanding as far as even for tax dues are concerned. But there may be another view is there that is maybe taken as the continuous in the nature. And we may be getting another law, but with the literal interpretation, which I understand with the taking the law of limitation in hand, we may go ahead in rejecting those claims. But I think whether the law of limitation is having any direct implication on the tax dues of 5 years, 10 years, 20 years, which is, but that I think Gupta Sahab may be right person.
So as the unit is closed in 2011 itself and no operations are there.
Yeah, but question is that if there is the recovery proceedings are initiated, something is recorded. I'm talking about if they are not able to prove anything under the exclusion of limitation period. If limitation in the most of cases of tax department, you will find some way limitation was extended by one or other reasons. But if something was not done, since department cannot sit silently for 10 years or more. But if something, anything is not done by the department in 10 years period, then certainly may be the case of expiry of limitation.
Sir, I submit
No,
they have
sir.
been writing.
Dubey,
Sir,
sir.
one moment. Sir, they have
I
been
do
writing
not-
letters.
Wait. I do not agree. The tax dues remain forever. There is no limitation about tax dues. They remain forever.
You mean to say the law of limitation is not applicable?
Not
Right of
applicable
having
and
not
further.
specific exclusion.
And further.
Yes.
And further. The law, that means the act, it empowers certain bodies, including the government, to forego the amount of penalty and interest, but not the amount of tax. Even the state government, that is the highest body, is not permitted to remit any tax benefit. The tax cannot be foregone because this was the money that was collected by the taxpayer from the consumer. It cannot be retained by him.
Issue is here, sir, basically, if it is not specifically excluded and if it not the something deemed extension is got under the law of limitation, then whether I don't foresee any case where the department may be silent in 10 years. There may be the genuine cases of extension time to time. But my issue is only that if there is certainly the case is falling under the limitation expiry under the Limitation Act, whether that is going to override the provisions or not, that is the issue. Legally, pure legal issue.
It
Certainly,
may be a question.
It cannot be waived. It has to be collected. But I don't foresee the department was totally silent and there was no case. There may be attachment. There may be the actions. There may be some actions which may extend the departmental dues, I think. But
just to give you an example, of course, it is not very much relevant. I joined the job in 1983. I started working since 1984. 1 year was training period. I came across a case, Awadh Bihari Gauri Shankar Depalpur, Indore, Madhya Pradesh. The dues pertain to 1951. Somehow I read in the news that the person was approaching state excise department to get a license for liquor. I went there, I attached the bank account and I got my dues realized.
But certainly the law, tax even can be recovered beyond the date. Even after the date.
That is what I am saying.
The tax can be collected from the states of the SSC and that is okay. But the question is that if something is time barred under the Limitation Act, whether it can be said by RP how he is competent to admit those dates, that is the issue. I think that is purely legal issue.
Yes, sir, should we move to the next?
Yes.
Advocate Gupta, if you can unmute.
Hello.
Yes,
Yeah.
you are audible.
Yes, yes. Good afternoon, gentlemen. It's a very nice pleasure to hear this August gathering. I had one query, Sudeep Gupta ji. I will be very happy if you could help me with this, please. I'm a liquidator in one matter, and I have now received state dues from central GST and service tax departments, which were not given during the CIRP to the RP. And I have received these claims after 7 months of my last date of claims. Sir, can you kindly guide me? How do I handle this?
You see, as per the latest judgment of the Supreme Court, the time limits are not mandatory. You have to, in my view, you have to admit those dues.
Okay.
And I think Dubey sir and Sanjeev sir, they may further
Even
comment.
Madam Gupta, I think when you are handling the liquidation, it is the altogether different new proceedings initiated. You have to consider all the things separately and independently.
Okay, sir. So, sir, in the light of this judgment, shall I write to them that I'll consider admitting their claims?
But certainly you have to take all the claiming. You have to take the supporting documents from the department.
Yes, yes, yes. So one of the claims was also, just as a gentleman earlier said, that it was at a SCN stage. One of the claims has been...
SCN, I am having my own fingers crossed. SCN is not demand.
Yes, sir. In that point of time, they had given an SCN which the matter did not resolve. And now suddenly, along with the penalty and interest, they are asking direct.
Now, during the period of now, what can be the cut-off date? That is, I think, yes.
Sir, as regards the SCN being before the SCN being after the date of insolvency commencement date, there is a judgment of Ahmedabad NCLT in a case of Bhuvan Madan insolvency professional. Sir is also joined. He is also one of the participant here. In his case, the NCLT Ahmedabad was pleased to declare that the adjudication or assessment can go on even during the CIRP process and the department can file its claim. So this is the judgment which was coming flow before Rainbow Paper. I think I would request if Bhuvan Madan sir can push or throw some light on this. I think there is some technical glitch. We'll move to the second, another question. That Mr. Hari Prasad is there.
Good afternoon, everybody. Sir, it is regarding the way that the very objective of the IBC, one of the objectives is to deepen, to make available the credit and deepening the credit market. But what will be the effect of this rainbow judgment on the deepening of the credit market? That is one point. The second point is, can we allow the government departments or tax authorities to sleep over their rights without filing a claim before the last date? Okay, there is a law and there is a lapse on the part of the resolution professional of not collating the whatever claims are there. But can it be taken advantage by the other party, maybe the government, to take it? And the last one is, sir, as IBC and insolvency professionals, are they being used as a special purpose vehicle to collect the dues of the government without any effort from them? That's all.
I think Pandey Saab would be the right person. It is the balance is more to the resolution.
Yes. I totally agree, because this has basically changed the fundamental contours of the court, this judgment. So here the financial creditor take the onus of resolution. They sit in COC, they spend on CRP cost, and they take normally the corporate debtor to resolution. They spend their time in working on a plan, assessing the feasibility, viability of the plan. Ultimately, when it comes to the distribution of fruit, suddenly the government accepting in the upfront that we take a backseat. So this is, I think, pushing the same fundamental of sovereign debt through a back door. So government has deliberately taken a backseat. Again, the court, I think, trying to become more loyal than the king. So they are pushing the tax dues through the back door. That I think is not good for the country, because the entire basis of IBC is lost here. We have climbed the ladder of ease of doing business because of IBC by almost 50 points. Just because, and then second point, as you earlier said, if you, that is a egg and chicken story, no? If you want all the golden eggs today, so you want to kill the chicken. So that is not the something to do. I think the company should survive, the corporate debtor should stay, and everybody gains out of that. You get employment, the bank gets their dues, and tax authorities get their future dues, even if they may compromise on their past dues, but they are assured of their future taxes. That is a benign way of looking at the code, which was the fundamental purpose. But now if you look very strictly in this judgment, they have not really understood the spirit of the code here. And they have really brought back that winding up logic, that if the corporate debtor is not able to pay, let it go to liquidation. That was basically the winding up under Companies Act. IBC said no, even if it is not able to pay the dues, you try resolution, try to revive the corporate debtor, but let it be a going concern. So all these fundamentals of the IBC, I think, have been disturbed by this judgment. Unless it is reviewed, I am very disappointed that I don't see much future for IBC after this.
Thank you very much.
I think Hari Prasad ji, law is against us today, and practical suggestions already given by Pandey Saab. But I think that today's legal position, we are having the judgment of Honorable Supreme Court today, and that is the literal interpretation of the law. Unless the law order is reviewed, unless we are going to amendment, we have to go ahead with this.
Quickly, we'll move to the another question. Mr. Sandeep Gupta.
Sir, this is Sandeep Gupta. I am an IP.
Yes.
And my basic question on the entire process is that the entire recovery, entire amount which is payable is determined based on claims. It is not based on their financial statements. And that is what is troubling a lot. Even in case of taxes, lots till the time returns are not filed, none of the tax authorities will be aware that what is the amount to be claimed. It is in the books of the company. And unless until we move to a situation where we are giving some credence to the last balance sheet and the liability of the company is determined primarily through claims as well as the balance sheet, things will not be in a good way and there will be litigations.
Gupta Sahab, just a quick view before moving to others. Basically, the law is expecting as Hanuman as far the IP is concerned in the company, and you are supposed
I will refer to regulation number 36(2). It says that B, the latest annual financial statements, audited financial statements of the corporate debtor for the last 2 financial years and provisional financial statements for the current financial year made up to a date not earlier than 14 days from the date of application. It further requires details of all material litigation and an ongoing investigation or proceeding initiated by government and statutory authorities. In my view, if these provisions, these regulations are followed, the situation will be before the person clearly.
Sir, I would like to disagree with you also. It is not only tax authorities, it is operational creditors also and everyone. We are very well aware with the experience that not even more than the 10% of the operational creditors makes their claims. The entire process is skewed towards the recovery of the financial creditors. They are made at the helm of the affairs. They are the COC. They appoint the IP. They run the entire process. No money IP can spend without their permission. They are the one who accepts the resolution plan. Resolution applicant is aware in case he can make them happy, he will able to go through with the resolution plan. He would always like to kick the operational creditors aside. tax authorities are still having some arms in their hands, but other operational credit do not have. According to me, if there is a balance sheet, whatever are the admitted liability in the balance sheet should be forming part of the claims, irrespective somebody is claiming or not. The separate claim should only for the things which a company is not keeping it in the books. So there is a books of accounts for a company, and that books of accounts is having some sanctity. That's what my view is. It is not a you. Litigation.
Thank you.
Like
very
in
much.
tax.
But
I think, let me respond to
Sandeep ji, just quickly, Sandeep ji, basically blindly going ahead with the books of account may not be in the right spirit of handling the RP or IP activities. There the law is prescribed in certain guidelines and some justification and substantiation of the claim. Certainly, we may have to sometime admit something which is not even appearing in the books of accounts if it is substantiated, and we may have to ignore even it is appearing in the books of accounts. This is my view.
Dubey, I'll add something to this.
Yes.
Basically, that is our experience. I am looking at 1,000 cases of CRP and liquidation.
Good.
The first thing any defaulting borrower tries to do is hide the books of account.
Yes.
You take it from here. Maybe some IPs are there. They'll agree with me. They will stop filing, completing or balance sheet for 3 years. When the company goes into CRP in 19, you won't find an audited balance sheet for 2016. That is the first thing they stop doing.
Yes.
To hide their all these malpractices. So we cannot depend on balance sheet because that is the first thing that takes a hit in an insolvent company. They will never finalize the balance sheet. The second thing, whatever they write in the balance sheet, there will be challenges to all those figures, even by tax authorities, OCs, that my figure is not correct. So that's why deliberately the BLRC and the code has not depended on the balance sheet.
Yes, yes. That may be the just a document and books of accounts to go ahead with the things, but that cannot be blindly we can accept, or something we have to accept out of that also, and something we have to reject even in there.
Sir, quickly we'll take one last question. Mr. Mayur Juktawat, educator.
Yes. Good afternoon, sir. Thank you, sir, for this this lecture. Sir, my question is, earlier there was section 26EA and section 31B of IDD-BVI Act and SURFACE Act, which gave priority to secured creditors. Now, thereafter IBC came, and IBC Law Committee report also mentions that the state tax dues and government dues will be given subservient nature of debt, and they'll be below the secured creditors. Now, if this rainbow judgment is applicable in today's scenario, now every banker will go into liquidation and not relinquish their rights and go under SURFACE and RDDB Act to sell properties and get maximum dues under liquidation. So the ultimate purpose or objective of the IB code will be defeated. And secondly, can this judgment be called a per incurium judgment? Because the relevant case, which is the Ghanshyam Mishra case, which is a Supreme Court judgment only, and it's a three-judge bench judgment. So that was also not mentioned in the judgment. So can we call it a per incurium judgment?
Mayurji, I think we have to go to again to Honorable Supreme Court and get this judgment reviewed. Unless it is specifically reviewed, we may be having very difficult to say what you are saying. And whether it is BLRC report, whether it is the preamble of the act, whether the spirit, everything, we are having the judgment of Honorable Supreme Court. So
yes, sir. If I may add upon, as regards the precedentiary value of rainbow paper is concerned, though Ghanshyam Mishra judgment being a larger bench judgment to certain issues on which the rainbow paper has not dealt with or decided, or even not even referred, leave apart overruling the Ghanshyam Mishra judgment. But today, for a high court or a NCLT inclined to not rely upon rainbow paper and to deal and differentiate, and keeping in mind Ghanshyam Mishra judgment is difficult unless and until Supreme Court reviews rainbow paper. That is another view. With this, there is one last question we'll take from Naveen Sood, sir. He has dropped a message. Yes, sir.
Yes. Good afternoon, everyone.
Good afternoon.
My question is with regard to Vidarbha Industries judgment, where the Honorable Supreme Court has held that if there's a temporary default, NCLT, the adjudicating authority, need not admit the case. Now, in one of the judgments of NCLT Indore bench, they have ruled that in a case which was filed by State Bank of India over 3 years ago, and the default existed for 8 years, they have ruled that 6 months time further time can be given to the corporate debtor, the defendant, respondent, to settle the dues. Do you think it is in line with the prevailing laws? Because if that was the case, then almost every case would be challenged and it will go to appellate authorities and Supreme Court. And what are the panelists' view on this?
I think Sood Saab, quickly, just Supreme Court has interpreted the Section 7 in May terms. Section 7 talks the May, and according to them, as far the financial creditors are concerned, this May word is going to have relevance in view of their position and all this. And where the law is literally had the cell in the Section 9, so it has to be deal with the May. And May means it has to be take the prudent exercise and the application while deciding anything to pushing to the insolvency. It should not read as sale. This is the challenge which we are having with the Vidarbha. Now we are having the case where we have to either pursue and fit our case. If we are on the defendant side, to if it is fit under the Vidarbha, then certainly maybe a challenging, and certainly it is going to be the very relevant and discretionary power with the judiciary, with the May interpretation, with the wider, they have dealt with the number left, right. And I think it is going to be the case to case basis judgment and application. And even the earlier, according to me, the earlier judgment of innovative also is going to parallelly play, where both judgments are going to play to decide each and every case to case basis. And as you rightly pointed out, whether it is 6 months, 6 years, or 2 years, whether it's the equal amount or lesser amount, whether when we will quote the judgment of Vidarbha, say that there was dues of 100 and against we are having award of 125, that's why it was good case. But even the court may consider, even we are having the 10 rupee to received, and as long as the date of say 50 rupees today, then say that he is going to pay 10 tomorrow, and he is planning proposed to pay remaining 40 in due course. So maybe just deferment may be going on. Whether it is in the right spirit of insolvency or not, I think over to Pandey Saab, he may be the right person.
Pandey sir can throw a much bigger light on Vidarbha judgment.
No, so basically, if you read the code, it's a very small law, running into maybe 20 to 30 pages. The bare act is very small and written in a very, very simple language. No complication, no cross references, nothing. So when I saw the law first, I was very surprised. In IBC drafting regulation, it's a beautifully written law, but somehow every aspect has been twisted and turned. So as coming back to this may and shall, if the DLRC committee deliberately kept the identification of insolvency simple by two things. They said there should be a proof of debt and there should be a proof of default. There also they provided for creation of some information utility, where if that issues a certificate of default, so the court doesn't have to peep further into any document. They will take it as a true default and admit. Purpose was that not to give this discretion, because if you go into the question of whether the company is insolvent or not, so this will take years. And I'll share with you with my experience that we at SBI were having more than 100 cases pending for 2 years for admission, despite the reports reading the law earlier as shall, not as may. They were taking 2 years because they were not confident of rejecting the claim, rejecting the application, but they said just kept sitting on it. That is the mentality, or I think the psychology of the courts, that I think there is some conflict between the way we, like old generation, are being taught up and the way country's economy is going. Today we are turning into a capitalist economy. All of us should agree. No challenge there. Every step government takes, we are moving towards capitalism. Okay. At the same time, we have social structure, social support, but we are going to capitalism. Whereas our judiciary, our leaders, many of them come from a training or education which is basically a socialist background. Entire political parties are based on socialist background. That is, I think, a challenge that this law cannot be taught to a person who will bring that equality to all, fairness to all. Ultimately, this is a purely commercial law which prescribes some priorities and which prescribes some timelines. And there is a logic behind that. Timelines, as I said earlier, because there is a time value of money. If you don't apply timelines, you lose money every day. And priorities, because that is how markets function. So in the capitalist economy, this is totally market-oriented law where you go to the market for a resolution plan, you go to the market for selecting an IP, you go to the market for everything else, for value everything. And then suddenly you bring socialism in between, the law will be confusing. That is what I think the courts are trying to do, like in the light of saving the sovereign, saving the jobs. Nowhere IBC said we are here to save the jobs. They are the side benefits. If the corporate debtor is revived, continued, jobs will be created, jobs will be saved, taxes will be generated, banks will get their dues. Even after taking some haircut, in future they can recover the dues. So these are the positives. But if you take a narrow view of the law, which is what here it appears that court has taken, then all these benefits goes up. So that is my view.
Right, sir. Sudeep Gupta, sir.
I do not have any comments on this aspect because if the case is delayed, there has to be some reason, and I'm not sure what to comment.
Yes.
Right, sir.
I remember there was one case. It was under SICA Act. It was real value appliances. This case said that the moment an application is filed, there will be moratorium.
Complete moratorium, sir.
Pardon me?
I think, sir, SICA is now very painful to remember. That's why we have all deleted from our memory. So
yeah, because that was,
we don't want to discuss SICA today. It was neither for anybody. Even in that era, that's why even the borrower was suffered. Everybody was suffered with that. Yes. Anything, Rohit?
I think Mr. Murli Krishna again has a question. With this this last question, we'll end up the session. I think the hand is raised by mistake. Yes. So, sir, it has been a great experience being with eminent persons as the panelists, and I honestly thank all the panelists for being here. And there is the participants have also cooperated and raised good questions and to enlighten us in the theme. With this, I would request all the panelists to permit the participants to take the leave, and thanks to all.
Sir, there is a technical glitch. I could not complete the query. In fact, you have given me an opportunity.
Yes,
it is a simple question. It is a simple question, sir. Many RPs have an apprehension that whether we can relax the timelines. 90 days is the limit for receiving claims. On our own, can we do? Are we having judicial power to relax? Or NCLT has to do it?
no.
Mr. Murli, I think technically as a RP, we cannot relax. We have to do our duty. And in the line of, I think, Supreme Court judgment, you can, as far tax dues are concerned, you may bypass this 90 days. But as far others are concerned, you have to say no. They have to go to NCLT and take the order.
Thank you. Thank you.
There are different positions.
Yes.
I think as far RP is concerned, literally you are bound by regulation unless you got the order. Now I think certain with the Supreme Court order, Article 142, you have to bypass that 90 days as far the tax department is concerned.
Okay, sir. Thank you so much.
Thank you very much. Thank you.
Thank you very much. Thank you all.
Thank you,
sir. It was my pleasure to have the two veterans from two extreme. I can just try to learn from both of you and to take my views forward.
It was my honor, sir.
Thank you very much. Thank you very much. Thank you. Thank you.
I'm thankful to Rohit sir, who introduced me to my senior Sanjeev sir, and